Good afternoon, Mr. Hofstadter.
Good afternoon, Your Honors. We're here today as a result of the trial court.
Do you want to save any time for rebuttal?
No, I don't.
All right, thank you.
We're here today because the lower court did not find that it had personal jurisdiction in this case that was brought under the Tennessee long-arm statute. The Tennessee long-arm statute was enacted in 1965, the current statute, and the purpose was to allow the Tennessee courts to exercise personal jurisdiction over non-residents who have sufficient minimum contacts with Tennessee. The statute allows Tennessee to hold individuals and business accountable in Tennessee for actions that have consequences in Tennessee when the individuals and businesses are not located in Tennessee. In 1965, electronic communications did not really exist in Tennessee as we know it today. The Tennessee long-arm statute, 20-2-223, permits a court to exercise personal jurisdiction over a non-resident Tennessee person in a claim for relief arising from that person's transacting any business in the state, contracting to supply services or things in this state, or causing tortious injury by act or omission in this state. In this case, virtually all the communications between the appellees and the appellant were electronic transmissions, with some telephone conversations. Electronic transmissions is transfer of data and information through electronic media, such as emails or DocuSigns. The electronic transmission is via the internet. The internet was created to establish a resilient, decentralized military communication network to survive a nuclear attack, allowing researchers and scientists to share information. The first email ever sent was 1971 by a scientist named Ray Tomlinson, sending a message from one computer to another computer in the same room. Today, email is the #1 communication method used for business communications. We are here because the lower court dismissed the appellant's complaints against the appellee for lack of jurisdiction, concluding appellee's communications with appellant were not substantial enough to give rise to personal jurisdiction. Holding the communications standing alone are insufficient to support Tennessee's personal jurisdiction over appellees in this case. Facts. The appellees are residents of Minnesota. The appellant is a resident of Tennessee. Appellees personally avail themselves for the opportunity to do business in Tennessee with their initial electronic transmission and email dated June 10th, 2024, being unsolicited email from appellees offering to provide financing service to appellant's equipment purchase from an unrelated third party. After the initial email, appellees had systematic and continuous electronic communications with appellant over a 3-month period. Appellee's intentionally and harmful conduct was aimed at the appellant by appellee's email communication dated August 28, 2024, of the need for appellants to send appellees by wire transfer $46,237.49. Appellant's position, it was defrauded of the $46,239.49. A very bad consequence of this electronic communications internet is the cyber crime, which takes place almost exclusively every day over the internet. The FBI statistics for 2024, cyber crime activity cost $16.6 billion. The problem with cyber crime activity includes personal cons where the victim is communicating with the fraudster. Historically, finding the culprit used to be by following the paper trail. Today, it's found by following the electronic trail. There are several cases that lead us to this personal jurisdiction, specific personal jurisdiction. Two Supreme Court cases, the case of Hansen versus Dinkle, established a principle that if the defendant availed itself of the privilege of doing business in a foreign state, then the Supreme Court case in Ford Motor Company versus Montana 8th Judicial District held that arise out of or relate to does not require a strict casual relationship. The personal jurisdiction long-arm statute looks to the personal availment by appellees in Tennessee. The claim arises out of or relates to the appellee's contacts with Tennessee.
Well, let's start with something more basic, though.
Okay?
Your assertion here is specific personal jurisdiction, is it correct? Am I correct?
Yes, you are.
So not general jurisdiction.
Correct.
So we're looking at a rare class of cases then. We're looking for substantial conduct. And the substantial conduct you're pointing to is all these series of, what, 9 emails?
No, there are the emails. There's more. I think there are more than 9 emails. We didn't get all the emails on record. We just pointed to there are numerous emails. They were constantly asking for information from us. We were giving them information. This was an unsolicited contact by the appellees. We will get you financing for this equipment you have purchased from an unrelated third party.
And how do the emails tie in to your client's claim?
They tie in because they came from an out-of-state defendant that we sued.
I'm talking about the underlying claim, the claims you're making in your suit. How do the emails specifically play into
The emails were constantly asking for information, trying to get their information. They were trying to provide financing, but in reality, the emails were structured to have the appellant send them money when there was no financing actually provided. So without the emails, the appellant would never have known who the appellees were. Without the appellee's constant communications with the appellant
I thought a third party introduced the two of you.
They did not introduce them. What it says is the third party told the appellees that he had a contract where we had agreed to buy equipment. And the appellees, on their own volition, reached out to the appellant, said, we can provide you with financing. The appellees probably didn't really need any help in providing financing, but the appellee's owner is about 78 years old. He thought, somebody's going to do it. I won't have to do it. Shortly in that time period, he realized that he had got himself in a bad arrangement. The equipment has been purchased. It has been financed, and it was.
And so this is you're saying this is an outright purchase and not an equipment lease?
Yes, it's an outright equipment. It's an outright equipment purchase. The equipment is purchased from a third-party vendor that makes industrial bagging that allows you to put mulch in a bag. And they have bought the equipment. They've got it set up. But what happened was the third-party vendor, the equipment manufacturer, told the appellees, that I have sold some equipment to this Nashville people. The appellees then unilaterally reach out and say, hey, we can provide you financing for the equipment. The owner of the company basically says, okay, if you can do it, that's fine. Months go on, 3 months, and he realized something's wrong here. But when they asked him to send the money, he sent it, and then said, this is wrong. And that's how I got involved at that point. But they reached out, they made the contact, not us. We had no way of knowing it. We didn't ask the third party to provide us financing. The third party seller, we didn't really need the financing. They have their own financial arrangements here. But he thought, well, this would be one less headache for me to deal with. We didn't get a chance because the court says they don't have specific personal jurisdiction. I got the feeling that the court was focusing on the email communications. And that's just where I felt the court was focusing. The problem with that is what has evolved over the years is email communications have changed drastically. In my world, I remember when you had a paper contract, everybody got around and signed it. Those days are virtually gone now. They're DocuSign. You don't really see the other people. And so what's happened here is, I think email and the internet has completely changed the way business is conducted. And our position is that electronic communications require, they don't have to have the paper. They have enough history that if you have electronic communications between the two parties, that can form the basis for a contract for DocuSign. That can form a basis that says you're doing business in Tennessee and we got cheated by you and we found you. And the court says, well, we don't have personal jurisdiction.
Does the record contain any evidence of the defendant having substantial conduct in Tennessee with others?
No, this is the only, we were early in this case. There has been no discovery done because we got kicked out on the get-go that we don't have personal jurisdiction. Right. We don't know. We've not found out what financing he's done with other people. What we do know is the manufacturer doesn't speak to him anymore. But we never got the chance to have our day in court. And I think the judge was looking at email, and I'm suggesting that the concept of email and electronic communications has replaced the paper. Like I say, we used to follow the paper trail, now you follow the electronic trail.
And neither defendant, the company or its executive, has a registered agent in Tennessee, nor does either of them have an office in Tennessee.
Excuse me? They have no contact with Tennessee other than this electronic communication.
Thank you.
I think that's what your question was.
Yes, sir.
Yeah, and I'm still a little confused here. I mean, I'm looking at, this is the Appellee's brief, but it indicates that it was alleged in the complaint that your client asked Premier Tech, the manufacturer of the bagging machine, for financing source referral. That allegation wasn't in your complaint at paragraph 9?
I'll be honest, Your Honor, I don't remember, but I do know that, and he could have asked him. I mean, I know my guy's always looking for.
What about Premier Tech provided plaintiff, your client, with the defendant's information as a referral source for financing? Paragraph 10 of your complaint?
That is true.
Okay.
They provided that as a source.
So they didn't come in, they didn't, you were introduced by Premier Tech then?
No.
The manufacturer, no.
No, we were not introduced by Premier Tech. This Appellees directly contacted our client. We didn't know who they were when they contacted us.
Okay, so, but paragraph 10 of your complaint, then that allegation's incorrect, or?
Would you mind reading it to me?
Sure. Premier Tech provided plaintiff with the defendant's information as a referral source for financing. I mean, that's what the brief says, so I'm not looking at your actual complaint.
Okay.
So if you want to say that's not in my complaint, that's fine.
I don't think it is, and.
Okay.
But what I do know is.
But if it is in your complaint, that's a totally different way of presenting.
It depends how you say the phrase. We know that the Appellees got our information from the third-party equipment company that we bought the equipment from. Appellees then contacted us. We weren't looking, per se, for them for financing. We knew how to finance equipment.
And you're saying your client never asked Premier Tech for financing source?
I can't say that one way or the other,
Okay.
Your Honor. I don't remember that specifically. I do know that they had no idea who the Appellees were. The Appellees contacted them and went through a barrage of trying to get financing, made financing to seem impossible, couldn't get it done, didn't know what to do. The deal fell apart. We still purchased the equipment, actually upgraded it significantly, got our own financing here in Tennessee. But in that process, we lost $46,000, and all of it was basically through electronic data going back and forth. And I think the court was saying that is not sufficient enough contact to give us specific jurisdiction, and we think that decision is incorrect.
All right. Thank you, Mr. Hofstadter.
You have any questions?
We'll hear hear from the appellee. Good afternoon.
Good afternoon, Your Honors. May it please the Court. My name is Peter Sulia with Pepper, Meeks & Whitaker here in Nashville, and I represent the defendants, S.T.A. Financial and Scott Anderson. I'd just like to start off with pointing out for the Court that at page 9 of the record, the amended complaint, paragraph 9, does in fact allege that plaintiff asked Premier Tech about financing source referral for the original quoted bagging machine. And in paragraph 10, that Premier Tech's June 10th email to plaintiff provided plaintiff with the contact information for defendant Anderson as a referral source for equipment financing. And defendant Anderson was CC'd on the email. That's also confirmed by Mr. Anderson's declaration that was submitted in support of the motion. He essentially asserted that he was put into contact with the plaintiff by Premier Tech, who is one of his business clients, and he explained how he provides financing services for customers seeking to buy commercial equipment from his.
And then paragraph 11 says plaintiff contacted Mr. Anderson.
It does, Your Honor.
Okay.
It does. So the idea that the defendant's contact with the plaintiff was unsolicited is just not accurate. The defendant did contact the plaintiff, and they did engage in some communications going back and forth in an effort for my client to obtain the financing to purchase this bagging machine. Although there's numerous emails alleged and telephone calls, we don't know what was said because the emails weren't provided or produced by the plaintiff, and the sum and substance of those communications weren't provided. So we don't know the nature and quality of those contacts. But those contacts are my client's only contacts with the state of Tennessee. As Judge Clement, you pointed out, they have no presence here in Tennessee. They simply don't do business here. Their business is wherever the customers of the vendors they provide financing for may be. They didn't reach out into Tennessee to establish a business relationship here. In fact, the only reason they had contact with the plaintiff is because Premier Tech, who is actually located in Canada, put them in contact. So I would submit that the lower court properly evaluated the contacts as not rising to the level of, and not being substantial enough to give rise to specific jurisdiction in this case.
How were the financing commitments provided to the plaintiff here? Were they attached to an email? Was this an e-doc sign type deal, or what was it?
They were communicated by email. I don't know if they were, if it was an electronic signature. Okay. It may have been a PDF. I just don't have an answer for the court on that. But in looking at the contacts that the defendants did have, again, they're mainly requests for information to allow the defendants to explore financing options from their home state of Minnesota. And Mr. Anderson's declaration also establishes that the financing was sought from lenders outside of the state of Tennessee. The only party involved in any of this that is located within Tennessee is the plaintiff. And again, the only reason the defendants had any contact with the plaintiff is because of the referral from Premier Tech. We'd submit that this communication is just simply not substantial enough. It's a random contact that was made through this referral. It was a fortuitous contact, and it's actually a very attenuated contact because, again, this is the only contact that the defendants have with the state of Tennessee. And although there have been advances in technology allowing people to communicate all around the world, that doesn't change the analysis of whether or not the contacts give rise to specific personal jurisdiction. I would refer.
Do the commitments themselves reference any jurisdictional requirements or have a choice of law clause or anything of that nature?
To my knowledge, they do not, Your Honor. I think I I referenced in our brief a couple of recent cases from the Tennessee Court of Appeals, one being Crouch, which was relied upon by the plaintiff in the lower court, and another more recent case of Baskin. And I would refer the court respectfully to those cases because the Supreme Court dealt with a similar situation of an out-of-state defendant having email communications in the state of Tennessee with a Tennessee resident. And of course, as the court is aware, in Crouch, personal jurisdiction was found because those email communications and the relationship between the defendant and the plaintiff in that case was very substantive. In fact, the defendant, the out-of-state defendant in that case, was involved in the contractual services that were being provided in Tennessee. In this case, in contrast, S.T.A. Financial and Mr. Anderson, its president, were not providing any services in Tennessee. Everything was from Minnesota.
And I'm assuming had the commitment carried through, the funding would never have gone through a Tennessee bank. It would have gone straight to Canada.
I believe it's in Mr. Anderson's declaration that the funding proceeds would have been paid to Premier Tech in Canada by a lender who was not located in Tennessee. And that would have created, and I believe that would have created a
So what is Premier Tech's, do they work like some sort of broker? Is that their role in the transaction if they're not actually the funder?
Premier Tech is the company that the plaintiff was seeking to buy the equipment from. They're the.
I mean, I'm not Premier Tech, I'm sorry, you're a client. Are they the actual funder of the?
I believe in this case, Your Honor, they were acting in the capacity of a broker.
Okay.
I do believe there are occasions where.
That's probably not the right term, though, I would imagine, like an intermediary or something of that.
It's the first term that came to
Okay,
mind, but I believe intermediary might be a more appropriate term. But my clients would utilize the information, the financial information, and present it to lenders in an effort to obtain the financing. In this case, as it's outlined in the affidavits, there were certain changes that had to be made to the transaction in order to secure the financing, which were done. The defendants presented the financing commitments to the plaintiffs, which the plaintiffs signed and then voluntarily sent their deposit. And then it's only later that the plaintiffs appear to have second thoughts about proceeding with the transaction and just simply asked for their deposit back, and it's alleged that the defendants declined after speaking with counsel. So based on those allegations, and as the plaintiff itself has framed the issue before this court, this is a breach of contract issue. This is not an issue of intentional tort or fraud, regardless.
Was it a TCPA claim?
It was, Your Honor.
Yeah.
But, you know, a TCPA claim can arise out of other than intentional conduct. And I would submit that when you actually read what was alleged in this case, as opposed to just how it's titled, it's pretty, to me, it's pretty clear it's a breach of contract.
Mr. Anderson describes in his declaration that his company, S.T.A. Financial, is I think he uses the term financial services company. I'm assuming that it's not a chartered bank like a national bank or anything of that nature. Probably not, since it doesn't have bank in its name. But
to my knowledge, it is not, Your Honor. It's a private.
So it doesn't have any state charters or anything like that.
Not that I'm aware of, Your Honor. But essentially, just going back to the minimum contacts analysis, the burden of proving the court had personal jurisdiction was on the plaintiff, and the lower court properly found that the plaintiff didn't meet that burden, whether through the allegations of the amended complaint and the allegations in the affidavits of the Scotts, who are the principals of the plaintiff. So we would submit that the Tennessee court lacked personal jurisdiction. We would submit that the lower court was correct in its analysis, and we would request that this court find the same way and affirm the lower court. And unless there's any questions from the panel, I'll conclude my remarks.
Hearing none. Thank you, Mr. Suglia and Mr. Huffstetter.
Thank you.
Realizing Mr. Huffstetter did not save time for rebuttal, we thank you for your arguments, and we will take this matter under advisement. At this time, the court needs to take a very brief recess to change panels, And we should be back within 5, 10 minutes at the most. Thank you.